morning by the time this is all over, so we'll see. What I'm here to do tonight is to kind of present to the City Council an opportunity for some options and discussion of this concealed carry license. I tell you what right now, I wish in all my years' experience that I could just walk up here and stand and say, this is, I think, what we need to do, this is where we need to go. Unfortunately, this is one of those situations, as you can tell, it's very emotional to a lot of people. It carries a lot of attachment, emotional attachment with it. But what I want to do is stand here tonight and present you with at least some options to look at and consider in regards to what direction you want to take as a City Council, what you want to do. As you can see here, I start off my PowerPoint, and I apologize to the people in back. Hopefully you can see that well enough. I'm still working on getting these slides down sometimes. But we're here to address the legislative issues and changes made in 2013 to the Personal Family and Protection Act, KSA 75-7C01, and its impact on city-owned buildings. I ask that we please understand tonight while I'm here is that we're not really to discuss the rights underneath the Second Amendment. Again, this kind of goes back to an emotional issue. I'm here to present to you what I feel to be the options of how we can handle if we want to exempt, not exempt, what we want to do as a city. Now, please understand, in talking with my counterparts, my contemporaries across the Johnson County area and in the Miami County, all of them say we're not really that worried or that concerned about public outbuildings or senior citizen centers or pools or whatever. We are basically focusing our attention on City Hall. That's where the majority of the business is transacted. That's where the majority of people work. So everyone I've talked to said, look, we're just going to deal with City Hall. So I took that lead. I followed it with them. As you can see on the second slide, we're talking about providing information in reference to the Kansas Personal Family Protection Act, guidance and options of the City Council, and to assist the City Council members in making a decision in regards to House Bill 2052 in the January 1st, 2014 exemption status. And I'm sure you all do because I watched the minutes, and they were quite interesting that night too, that you first discussed this on June 17, 2013. That's when this issue first came up about whether or not we want to exempt City Hall. So there's already been some previous discussion of it. What really happened is in 2013, the Kansas legislators enacted two bills that really made significant changes to the Personal Family Protection Act that affects the responsibilities of the concealed carry license holder. And as you can see down in my second paragraph, it also talks about numerous changes to the Act. One significant change in the law governing when a state or municipal building or buildings may exclude concealed carry license holders from carrying concealed handguns into the building. Taking a quick review of General Section 2, it says that on after July 1st, 2013, any state or municipal building must have adequate security measures in place to prevent any weapon from entering a building and properly post Attorney General approved signage if that state or municipal building desire to restrict the licensed concealed carry of handguns within its wall. It comes from the Attorney General's office, state of Kansas. What's meant by adequate security? What do we know? What is adequate security? The state clearly defines to us in this statute what adequate security is. It tells us you will have these items in place for you to have the adequate security. Adequate security measures means the use of electronic equipment and personnel at public entrances to detect the carrying of any weapons into the state or municipal building, including but not limited to metal detectors, metal detector wands, or any other equipment used for similar purposes to ensure that weapons are not permitted to be carried into such buildings by members of the public. It says must also provide adequate security measures for storing weapons, gun lockers, etc. Again, this is coming from the Kansas Attorney General. What would be the next question? What's going to be adequate security, and what's it going to cost us? What's it going to cost the citizens of Gardner? I just did some quick scans, very quick scans. The cheapest Garrett Magna scanner, which is a walk-through scanner that we can purchase, is $7,998. Or I'm sorry, $3,999. We need two of them. We need one for the south, one for the north entrance. Okay, so we're up to $7,998 for just the scanners. Well, let's say we can go out and talk to a couple of officers part-time or who have retired and said, we want you to come in and provide security so we can exempt our building. Well, let's say we get lucky and get them at $30,000 a year because they're already retired. They're drawing their KP&S salaries for retirement. Well, that's $30,000, but let's say now we've got to pay them benefits, there's another $15,000. So, again, rough approximations. We're up to $45,000 a year. Times 2, that's $90,000. The first year cost is $98,000. Second year cost, we take away the cost of the metal detectors, and it comes down to $91,000, roughly. Okay, here we go. What happens if the adequate security measures cannot be enacted by January 1? CCLs, or concealed carry licenses, allowed in buildings to include City Hall. Employees may carry weapons if not prohibited by policy, city policy. All right, here we go. Are there other options? Absolutely. The state of Kansas does allow for a final 4-year exemption. We find that underneath the listed chapter, Chapter 75. And let's look at that for a moment, please. Here it is. Subsection I. Thereafter, such governing body or chief administrative officer may exempt a state or municipal building for a period of only 4 years by adopting a resolution or drafting a letter listing the legal description of such building, listing the reasons for such exemption, and including the following statement. Here is something very careful. And we need to make sure we understand what we're looking at here and what we're addressing here is totally different than security measures. They're two separate things. I myself, at first, when I was looking at these things, reviewing them, were at times getting a little confused about it, but I called Chuck Sexton, the Attorney General who deals with concealed carries. We discussed it, and he goes, no, they're two separate things. So let's talk about it for a moment. A security plan has been developed for the building exempted which supplies adequate security to the occupants of the building and merits the prohibition of the carrying of a concealed handgun as authorized by the Personal Family Protection Act. A copy of the security plan for the building shall be maintained on file and shall be made available upon request to the Kansas Attorney General and law enforcement agency of local jurisdiction. Notice of this exemption, together with the resolution adopted or letter drafted, shall be sent to the Kansas Attorney General and law enforcement agency of local jurisdiction. The security plan shall not be subject to disclosure under the Kansas Open Records Act. Okay. The next reasonable question is, what's a security plan? What is it? How do we define it? What do we know that it is? Well, I got news for everyone. Kansas doesn't let us know. No one really defines what that is. In talking with CARET, Kansas Eastern Regional Insurance Trust, they basically kind of gave me a very nebulous type of, you know what, security plan. Statute doesn't really address it, but what's reasonable? What would the ordinary person expect to be reasonable to protect our employees or protect the citizens in this building? What is reasonable? Well, we have to do a security assessment of the building. We have to find out, which we talked about last city council session in some ways, some manners, where is it maybe we have some areas that we need to address? You know, what's the safety measures? The state's going to look at, you know, what safety measures have you enacted? If you're asking for an exemption, what have you done to really go through and guarantee the safety of the employees and the citizens? Well, you see down at the bottom, I listed, for the most part, from what I can field and what I can find out, ballistic glass, panic buttons, in-service training are all reasonable efforts. Okay, that's all good and great, but where does this really lead us to? Options. Options. Kind of listed out options A, B, and C. Okay, here's my other thing for you. I really wish that I could come into play on the Goldilocks principle. What's that? The soup's not too hot, it's not too cold, it's just right. I don't know in some ways if there's really just one that's just right, that covers everything we want to address, deals with all the needs, and deals with all the specifics that we have to deal with. But this is what we're coming up with. Option A, install security measures as outlined by state statute. Metal detectors, full-time persons, continue to restrict employee carry by policy. Okay, let's look at option B. Yeah, let's kind of drill down deeper in option A, B, and C a little bit later on. Remove CCL prohibited notices and allow carry in buildings. Make changes to rotunda or service windows, ballistic glass, panic alarms, etc. Continue to restrict employee carry by policy. Option C, develop a security plan and request additional 4-year